We're here because on December 23rd of 2024, the following took place. It's that basic. But we're going to talk about the instructions that were just read to you, the facts and the elements of those instructions, and what you've seen in the videotapes. Now, some of you might be sitting there saying, well, what about the other guy? What about the other guy? You have an instruction there, and you took an oath to follow the law, which is, you are here to determine whether the defendant is guilty or not guilty from the evidence in the case. You're not called upon to return a verdict as to whether another person is guilty or not guilty. So if the evidence in this case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Throughout the course of today's arguments, I submit to you, probably all three of the people, me, Mr. Arnold, and Mr. Giacomo, will tell you Mr. Hamilton is guilty of the same charges. And we're going to go through that. We're going to look at the same elements and apply them to both at times. Now, during voir dire, there's a really interesting comment that one of you made. And the question was, how do you discern two versions of events if you don't know the people and they tell you, I think in that context it was kind of verbal stories. They tell you two versions of events. How do you discern, which one is telling the truth, which one's not? And the answer was, whomever sounds more wrong. So it struck me, and as I was thinking about that today, I wanted to highlight that because that's an unusual dovetail into this instruction. Because this instruction right here, you don't have to determine who's more wrong. We're going to tell you all day today. I submit you both sides. You'll hear it from different times. Both are wrong. So you need to look at the law and the elements and see if it matches what you've been given. So, at no point today, some of you might be sitting there saying, who threw the first punch? Whose skin touched right before the other person? Or maybe who won the fight? Maybe you're looking there and kind of grading it like a boxing ref. No one is ever going to ask you to make a determination between Mr. Hamilton and Mr. Davis. And submit you, Mr. Hamilton is guilty of battery by prisoner and challenge to fight also. But that's why on the front of that packet it is the state of Nevada versus Duane Davis. Because those are the charges. Those are the elements. I know a lot of times we watch television and we see that line. I always cringe a little bit when I see it, where during the course of some Lifetime movie, the person says, oh, I want to press charges. I don't know what that means. I see it all the time, but there's not a situation where it's Hamilton versus Duane Davis. It is laws enacted by the state of Nevada and whether or not a defendant's conduct meets those laws and those crimes. So, in getting into essentially the laws and the elements, let's look at first just how a defendant characterizes what occurred in his own words. So just kind of, how does he characterize it? They released the video of you. That was the line that's said to him. He says, did you see me get him?
They released the video you farted. See me get him? Well, but you coming off like that too, in your head.
Submit you, that's actually a pretty fair kind of recitation of what happened. Yeah, a little bit, but he got you too. Yeah, it's because it's mutual combat. So let's look at what battery by prisoner is. First, we'll go through the elements of battery, and my kind of job as the first closing is to give you a little, kind of like a law school lecture. So those are the instructions, and no matter what I say, those instructions are what govern. Her Honor gives you those instructions, that's what applies. I'm here to take some of the facts, some of the video, and then highlight some of the elements and explain different terms, why things might be there, what those mean. So, what is battery? It's a willful and unlawful use of force or violence upon the person of another. Now, the force need not be violent or severe. and need not cause bodily pain or bodily harm. So some of you might be wondering, hey, why didn't anyone say who got hurt worse, who was bleeding, who had a bigger bruise? It's because that's not an element of battery. Now, throughout the course of this closing argument, I will tell you about what is not elements. And that's because, if you think about yesterday, during voir dire, over and over, you heard the state has the burden of proof for each and every element of the crime charge. Now, we always kind of focus on the state has the burden of proof beyond a reasonable doubt. But have you ever noticed we usually don't talk about what it is that the burden applies to? Well, the burden applies to those elements in your instructions. So that's why a lot of times in those same instructions, you will have things that are not elements. Likewise, if something's not in your instructions, it's not an element of a given charge. So I might highlight that. It's an intentional and unwanted touching. Now, we'll come back to the willful and unlawful because you have another kind of instruction on that. But just so no one kind of gets confused about this, at no point is someone going to stand up here today and say, hey, challenge to fight. If the challenge is accepted, then it's a wanted touching. That's not what that means, okay? So that phrase, intentional and unwanted touching, is if someone, I'll give you an example. If you're in an elevator and you guys are in a crowded elevator and someone kind of has a seizure and involuntarily hits you, it wasn't willful, essentially. It was an involuntary spasm that hits someone. So it wasn't also intentional. Now, this one, it's intentional and unwanted. Don't confuse challenge to fight with wanting it. Just because you accept the challenge doesn't mean you want it. Force or violence upon the person of another. Force or violence need not be severe. Boom. Now, what is also not in those instructions? There's no requirement of pain of a body part used. You don't have to hit with a fist. You don't have to kick. There's not a number of times struck or how hard it has to be. By prisoner. This one's pretty straightforward because you saw a video of CCDC, but I'll just kind of take you through because I'll give you an example about why this instruction is the way it is. So, if the battery occurred and the defendant was a prisoner in lawful custody or confinement, submit to you, he's in lawful custody or confinement over at the Clark County Detention Center. You're not going to hear that that's not the case. A prisoner includes any person held in custody under process of law, lawful arrest, or deprived of liberty, kept under involuntary restraint confinement. So that's just a situation like, for example, lawful arrest. If the cuffs, out on the street, an officer actually gets a hold of a suspect and actually puts the cuffs on them and they're on them, that person is now detained and under arrest. If that person were to kick, punch, boom, that would actually now fall under this battery by prisoner situation if the cuffs are actually applied and they're taken into custody. And so that's why there's different levels of that. If you're looking at that instruction and wondering, well, this one's in the jail, it's pretty straightforward. Yeah, there are times when it wouldn't be as straightforward. Now, I want you to think back also to yesterday during voir dire. And even during a lot of your questions today, a lot of the jury questions were good and reasonable, questions that you would be thinking. And that's because you don't actually have the elements or the instructions on the law. So sometimes yesterday we spent time saying, okay, well, there might be different rules inside a detention center. You might have two bad choices, fight, or you could get punked, things like that. But if the instructions don't give some exemption for kind of two bad choices, do I fight, do I run behind the officer, do I say, put my hand up, and then someone tells how bad I look during this interaction? No. The elements of battery don't have that exemption. So it's reasonable that you asked a lot of those questions, similarly when we talk about like the control room and things like that. But if it's not an element of battery, then it is not to be applied by you when looking at the facts. What is willful? Willful and unlawful use of force. This kind of dovetails with what we were just talking. So willful is a purpose or willingness to commit the act in question. So it does not require any intent to violate the law, to injure another, or to acquire an advantage. So let's say it's that situation where, hey, no inmate wants to act like they're scared of a challenge. That is not an exemption. If the act of moving forward with your body, touching the other person with your body, hitting them, the grappling, the fighting, then the elements of battery are met. You don't have to intend on, hey, I'm going to make this contact and it is going to be a violation of the law. And I hope to injure that person or acquire some advantage so that people think I'm tougher around. That's not an element. Likewise, there's no exemption for both people wanting to fight. Hey, both people want to, it's okay. No. Commands are being given, pepper spray is being used, multiple officers are attempting to pull Mr. Davis, Mr. Hamilton off each other, and some issues, it's actually pretty fair as far as who got in blows, who got in fights. Realistically, this is a pretty good example of how once you start throwing punches, you kind of lose the advantage of holding body weight on the other person, and they flip you over, they get a turn. But this is mutual combat. The elements of battery are met. Now, you have an instruction there. Some of you might be saying, yeah, but why? Why did this happen? What was that chirping underneath the cell doors that you heard about? What was this prior discussion? Now, motive is what prompts a person to act. What prompted this fight? This what's up, what's up? It's not an element of the crime charged. So you have that as one of the very first instructions. The state's not required to prove why it is they fought. Now, the motivation or whatever that previous talking shit was that was referred to, it's not an element as to what they were talking about. Now, this is the first call from December 25th, 2025, when Mr. Davis is just out of the hole. So, now, with any battery type situation like this, we're going to now transition to self-defense. We're going to go through a series of instructions because the law in self-defense has several instructions, and at the end, I'm going to tell you why self-defense is not applicable to the situation that you have watched all day today. So what is self-defense? It's willful and unlawful use of force or violence upon a person or another. That use of force in self-defense is justified and not unlawful when the person who uses the force actually and reasonably believes imminent danger that the assailant will cause him bodily injury. So look at Mr. Davis, look at Mr. Hamilton. No imminent danger there. And it's absolutely necessary under the circumstances. It's not absolutely necessary that Mr. Davis here starts veering towards Mr. Hamilton. Now, at no point when I discuss Mr. Davis's actions, I'm excusing Mr. Hamilton's. It's mutual. Like, so just right now, the fact that Mr. Davis starts veering towards him and Mr. Hamilton's still leaning up against the sink, Mr. Hamilton walks towards him a second or two later in this. But what I'm saying is there's no imminent danger. This isn't absolutely necessary. There's a man in there with a taser, with OC spray, a guard, who could separate these two, who could provide either one safety. A bare fear of bodily injury is not sufficient to justify use of force. Circumstances must be sufficient to excite the fears of a reasonable person placed in a similar situation. The person using that force must use that force under the influence of those fears and alone, not for any other purpose. So you can't use the situation to your advantage. You can't kind of create the situation and use it to your advantage. We'll talk about that here. So Mr. Davis, when he's discussing what occurred, what does he say? Big dog handles his business. I'm proud of myself. He got back at the guy chirping and talking shit to him. The right of self-defense is not generally available to the original aggressor. I am not going to tell you either one is the original aggressor here. They move in unison. Look at those photos. Look at that video. Look how the body language mirrors them. Look how the words even mirror each other. What's up? What's up? So the person that sought the quarrel with a designed force. Now, this next line, and create a real or apparent necessity for making an assault, that, don't get confused with that, that's a situation where if you provoke and cause a situation where, oh, now I'm actually really in danger and need to use self-defense, you can't create that and now take advantage yourself, all right? So either real or apparent. But here's kind of the key with regard to this instruction with what we've seen. Without voluntarily seeking, provoking, inviting, or willfully engaging in a difficulty of his own free will, they go at the same time. There's no one with an advantage over the other one. Look at how both of them split the fight. They split the aggression towards each other. We saw this photo earlier today and discussed as though Mr. Davis kind of, I don't remember quite how it was discussed as far as, not that he was taken off guard, but he was just standing there. He's completely turned away from the door, away from the officer. This is not a situation where he is standing there in a totally defenseless position. What do I mean by that? Let's look at this moment in time as it actually occurred. It's a great screenshot from Mr. Davis, hands down. Now you heard his fists were clenched, but his hands are down. Let's see how long this lasts in real time. Ready? Let's go back, because that was longer than I expected since it paused. There it is. There's just, it literally is a transition from bottom to top. Let's look at it again. The screen, the still images on the right, up at the top. That's in unison. One more time with the staggered view. How does the defendant characterize what occurred in his own words? Why? I got in fights. With who? The little dude. I body slammed him.
I was
His name's Rob. I don't know if he's calling him Rock, but you could see how someone might get that nickname from Rochelle and Hamilton. What else did we have? Why'd you get in a fight? What did he do? Trying to rush me. He's just been talking. So it wasn't a discussion about sharing coffee, though. We had a question earlier as far as like, oh, you don't know what they were talking between the doors. It wasn't coffee. Self-defense. A person has a right to defend from apparent danger to the same extent as he would actual danger, if in his mind an honest belief and fear that he is about to suffer bodily injury, and he acts solely upon these appearances and his fears and actual beliefs, and a reasonable person in a similar situation would believe himself in like danger. Last kind of one we'll go through here, the appearance of danger must be so urgent and pressing that in order to prevent his receiving bodily harm, the use of force is absolutely necessary. Don't say necessary, absolutely necessary. So when self-defense or evidence of self-defense is present, the state must prove beyond a reasonable doubt the defendant did not act in self-defense. You have one other instruction after that, and I submit to you that that other instruction carries the entire burden, especially with regard to the self-defense situation. What does that say? It says a person who voluntarily entered into mutual combat is not entitled to rely on self-defense or the no retreat rule. So if you engage in mutual conduct, if you accept the what's up, and you're both involved in it, you don't get to later say self-defense. You don't later get to say, oh, I just wasn't retreating, I was standing my ground. Now, just to kind of clear up one thing, and I'm not in any way suggesting that this was Mr. Arnold's kind of contention here, but some of you guys might go in the back and wonder, because it was thrown out. Mr. Arnold asked an officer, hey, isn't it true that Rochelle Hamilton was also charged with mutual combat? Don't be confused by the question. There's no charge of mutual conduct. That's not what Mr. Arnold was referencing. He was kind of referencing was charged with kind of the same crimes. There's not a situation where mutual combat is the charge you're looking for to negate self-defense. Mr. Arnold was just using that term with regard to what happened in the video, which is reasonable. Fight continues. Orders are given by an officer. Pepper spray is used. These two men do not stop. 3 officers are trying to pry them away. The grappling, the fighting, the punches continue. That use of force is not, even if it was necessary at the beginning, which I submit to you it wasn't, it's not necessary when 3 officers are trying to pull you apart and can't for roughly 7 seconds as you continue. You're not in danger. Now, you heard kind of that Mr. Hamilton positioned himself behind a pole. Is he behind the pole or is he at the same sink that he was at? Look where Mr. Davis is and Mr. Hamilton is still at the sink. Isn't there a better place to hide if you're going to hide behind the pole? Wouldn't you get actually behind the pole? Do we know if Mr. Hamilton thought, I wonder if that's the guy with my razor? Or was he just sitting there waiting to get his razor so he could shave his head? Or, if he was hiding, is he hiding from Mr. Davis or from the officer? Because Mr. Davis sees him the whole time. He's not hiding from Mr. Davis. We heard the term lying in wait several times. That's a legal term. You don't have a lying in wait instruction in your instruction packet. He's not hiding behind that pole and waiting till the opportune moment of Mr. Davis to walk by and hit him on the back of the head. This is face to face. You don't say what's up to the person you're hiding or lying away for. You don't go face on and say what's up, and then begin. That's not what lying in wait is you hide behind bushes somewhere and then ambush somebody. Now, we'll look at this just because, so we'll look at a minute or so of this. The officer leaves, Mr. Hamilton is still by the sink. Takes off his shirt. Soaps his head. See Mr. Davis with the officer at least over there, still soaping the head, getting it ready, waiting for the razor. At this point in time, Mr. Hamilton does at least notice something at that door. He walks over there, sees, it's a door that's see-through, so you can probably see on the other side. Was he looking and immediately noticed it was Davis? Was he looking for his razor? Does he go anywhere? Does he hide? Does he crouch down? Does he just stay at the same sink that he's at until right before the moment both people go at each other. Challenge to fight. Let's count 2. If upon previous concert and agreement, a person fights with another person. So let's look at this, because I'm facing you. I might clench my fists. I might be nervous. I might say what's up to someone in the hall. But you, as ladies and gentlemen of the jury, get to determine what the evidence actually means and what the intention was between these two. And you get to use circumstantial evidence as well as direct evidence. So that posturing that you heard the officer say, that's assaultive, can't remember his word, but assaultive posture, or I would try to get in between the two, that's what that is right there. That's what that puffing of the chest of both men is. What's up? What's up? Language mirroring each other. I told him, I got him. I told him every time he see me, he have to get along. Mr. Arnold's completely right. Mr. Mogg, Detective Mogg is not going to be able to tell you whether or not he said that before the fight, after the fight, screaming it during the fight. But what does it also tell you? It tells you the exact same thing that we kept talking about today, is when they see each other, they know it's on when they had that opportunity. Listen to that phrasing again. And that's what he did. Saw each other, had the opportunity, took it. Intention, and what they meant by those phrases, those posturing, you can look at the video. We don't have thought bubbles that we kind of walk around with all day long that tell us our internal thoughts. But intention is a question of fact that you, the jury, gets to infer from defendant's conduct and all the other circumstance and evidence that's been given to you. So, one of the things that I always point out is circumstantial evidence, the law makes no distinction between the weight given, either direct or circumstantial evidence. So the phrase, what's up to you, and what it meant, and the actions and context in which it was given, you get to apply the same weight to that as you do the first punch, the first struggle, the first headlock, the continued fighting on the ground. Now, what are you not going to find anywhere in those instructions? Because some of that's going to be important as to refocusing as to what the elements are. You're not going to see a single thing about best practices of Clark County Detention Center. I don't know what they are, but at no point in those instructions does if best practices were not given on December 23rd, 2024 at 9:30 a.m., then it removes the elements of battery. That's not there. What's the common practice? Was this a breach of security? Those lines were thrown out and effective. I mean, that is what Mr. Arnold should do. So me pointing this out is not to disparage, or it was very effective. Now, it's the state's job to remind you about what the elements are. Those aren't in there. Look, is it best practice to lock your doors at night or to have a deadbolt on your home so that someone doesn't break in? Yeah, it is. But that doesn't negate the elements of breaking into someone's home. The officer doesn't show up at your house and say, hey, did you lock your door last night? Hey, your car was stolen. Did you paint that red? Because we have had a rash of car theft of regular. No. Those crimes have elements applicable to them. And what happens in someone's home, whether it's locked or not, is not one of them. We kind of went over this card, but I'm going to point it out just because I'm also going to point it out under the concept of, how no one was hiding or lying in wait. Because in order to be hiding or lying in wait, Mr. Hamilton would have had to accurately predict the exact moments in time when the officer would be looking down at a car and happen to look up when there's a pole and then look back down. He would have to guess that spot on. So let's look. Mr. Davis has complete line of sight. The officer's looking at the car. Officer's not required to memorize every single cellmate, or sorry, cell location. So that, hey, Mr. Davis is exactly on 7D, room 9, room 11. He's not required today, he's looking at the card. Now, continues, officer's head comes up, and look, oh, happens to be the moment when that pole's there. Sir Hamilton can't guess that. He's still standing there with, like this. Why isn't he behind the pole? Why isn't he crouched over in the far corner hiding then? And then the officer just happens to look down again at the exact moment when Mr. Davis is turning the corner and starts to veer towards it. Mr. Davis, he's not snuck up on Mr. Davis, he sees him. What are not elements to these crimes charged? It's not an element that inmates have to act like they're not scared of each other. And have to accept the challenge. There's not an honor exemption somewhere in those instructions. The control room, whether or not they open the door, whether or not they're Metro employees, whether or not they have access, these are all actually really good questions, but they don't negate the responsibility of the two individuals that decided to go at it. Those are the two individuals who are being held accountable for those actions, not the control room. Control room, that's some job that may or may some manager may or may not have said, yeah, why'd you open that up? Is it unusual for an inmate to be alone in that room without an officer? Yeah, that's what they said. Doesn't negate a single element. Whether or not Nevada's facility would do something different than Kansas's facility, not in there. It's Roshan Hamilton and Duane Davis that decided to engage in that conduct. They are the ones that the state is standing before you today and saying, today, in this particular trial, it's Mr. Davis's trial, hold him accountable for what he engaged in. Now, earlier when I said, look at how the words mirror each other, look at how the body position, no one has snuck up or gained an advantage. Look at how it mirrors each other. Squared off. Initial movement. Back foot gets stability by pushing off. Front foot gives to get power while you brace with the back leg. This is the first moments of this fight, and it couldn't be more mutual. The elements of battery, it's what you have been met. Mutual combat based on challenge to fight has been shown to you. Defendant Duane Davis is guilty of counts 1 and 2. And just for one last visual, when I just showed you those 4 photos, let's look at them again. Let's cut off the top. Fists clenched, squared off and feet angled towards each other. Going towards each other while bracing the leg, almost equidistant right there. Hands both now up in fighting position or attacking position, front leg bent. The push-off moment as they're really accelerating towards each other. Both leaning in it the exact same way. It's not a defensive posture by one while the other's attacking. And then the moment of first contact, you almost can't make that up if you were going to. Look at that. Look at the hourglass figure, I guess, at the top. The bracing. It's the moment they first have contact, the bracing of the back leg and the front leg. This is mutual combat, and Mr. Davis is guilty of counts 1 and 2. Thank you.